Ready to begin?
Yeah.
Okay, great. Excuse me. It's 9 o'clock on 12/19/2023, and I'd like to call this meeting of the Electoral Board of McHenry County to order. The board is constructed of 3 members, myself, Joe Terrio, representing the county clerk's office. And introduce yourself, Norm.
Norm Vinton on behalf of the State's Attorney's Office and on behalf of Patrick Canale.
Robin Shetley on behalf of Catherine Keefe, Circuit Clerk.
Assistant State's Attorney Tom Cahill on behalf of the State's Attorney's Office representing the board.
Very good. This board is convened to hear the petitions of the objectors as listed in the McHenry County Board, McHenry County Electoral Board docket for today, 12/19/23. The objections were filed 12/11/23, and notice of call was given to the McHenry County Electoral Board on 12/13/23. The board's notices of today's hearings were served on the parties as required by the Illinois Election Code. Is there a motion from the board to adopt the board's administrative rules?
I will make that motion.
Is there a second?
I will second.
Very good. And we'll take a moment to sign those.
Anybody needs a copy of the rules or?
Excuse me. For those involved, because of the possibility of judicial review of the board's decisions, a court reporter is present to ensure that a verbatim transcript of today's proceedings is made. She also may administer oaths as we proceed forward. Excuse me. I may be clearing my throat several times during this. I apologize. The electoral board hearings are subject to Open Meetings Act, and that public notice was posted in writing 48 hours before this hearing. There is an opportunity for public comment. Did we have any?
We don't have any.
We do not have any. Given that, we'll call the docket. There is one objection. The first hearing is 24 MCEB01. The objection of Eric Carl Hendricks to the nomination of Robert C. Nowak as a candidate for County Board Member District 3. Objector and candidate, are you prepared to proceed?
I am.
Yes. Please identify yourself for the court. State your name, firm, and address if you're representing a firm.
Eric Hendricks, 3 Castle Pines Court, representing myself. 3 Castle Pines Court, Lincoln Hills, Illinois, 60156.
Robert Nowak. I'm at 1071 Kings Mill Drive, Algonquin, Illinois. Representing myself.
And Ms. Court Reporter, would you administer the oaths?
Yes. Raise your right hands, please. Both of them.
I do have a
He's an
preliminary.
Oh, you're an attorney. Right, I apologize.
I have a preliminary motion. Should we address that
It'll be
after this?
right after this.
Okay.
Yes, sir.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give, Ms. Goss, will be the truth, the whole truth, and nothing but the truth?
I do.
Right. So you have a preliminary matter, Mr. Hendricks?
Yeah, I would just ask that this electoral board, I'd make a motion that the electoral board here take notice of Mr. Nowak's filings, and I would be admitting that as, I guess, evidence in my case.
Take notice of his filings, just to make sure I heard you correctly?
Yes.
Okay.
Specifically, what I've objected to in his petitions, which are specifically the statement of candidacy, as well as his petitions, his primary petitions.
And do we need to make a motion in a second to agree to that?
Well, Mr. Nowak should probably get an opportunity to address that motion, whether he objects to it or has no objection.
Do you have any objections to that, Mr. Noe?
I know.
Yeah, then it's adopted.
Okay. It has been adopted and any motions, Mr. Noack, preliminary
No.
motions?
Will Mr. Noack I won't have any witnesses other than, perhaps myself and Mr. Noack. I would also make a motion to exclude if Mr. Noack plans on calling any other witnesses.
I have no plans of calling any other witnesses.
Agreeable, all right, thank you. With that, the objector may proceed by presenting his case and argument for the relief requested.
Will we be doing both facts and argument simultaneously, or?
Sure.
Yeah, that's fine.
Okay. Well, it's a pretty simple argument, I think. Mr. Noack filed his campaign filings, his nomination papers on or around December 4th, 2023, within the deadline on the petition or the nomination papers in question, specifically the statement of candidacy, as well as the petitions themselves. He nominated he either caused to write or he typed in the Republican Party. The Republican Party isn't an established party, and on information belief, it's not a party, new party or established party under the law recognized by the territory of the state of Illinois. Section 710 of the election code does include that each petition must include as part thereof a statement of candidacy. Moving on to the statement of candidacy for a second. There are mandatory provisions in that. There's both directory and mandatory requirements under the Illinois Election Code. It's commonly understood as a matter of judicial interpretation that anything that includes wording such as shall or must is mandatory. That's a requirement. Without that requirement, the petition on its face would fail. So, or the campaign filings, I should say. And I'll just read briefly 710, part of 710. Each petition must include as a part thereof a statement of candidacy for each of the candidates filing or in whose behalf the petition is filed. This statement shall set out the address of such candidate, the office for which he is candidate, shall state that the candidate is a qualified primary voter of the party to which the petition relates and is qualified for the office specified. And also shall request that the candidate's name be placed upon the official ballot, be subscribed and sworn by such candidate before some officer authorized to take such oath. I summarized the when a mandatory provision is violated, there's a bunch of case law that talks about when it's fatal to the nomination papers versus when it's not. Sometimes, if it's mandatory, the general rule tends to be that it is fatal. There are requirements that I just read stating that he's the primary voter to which the petition relates. You can see from the face of the nomination papers themselves, both on the statement of candidacy and on the petitions, there were, I believe, 23 total times opportunities for the candidate, Mr. Bob Noack, to essentially state to the petition signers as well as to the county clerk or the election authority what party Mr. Noack intended to run for. All 23 times it was spelled the exact same way. It was sworn or it was notarized by him a total of 6 times. Every single time it was the Republican Party. By writing in the Republican Party, there's 2 things. One, on the face of the nomination papers themselves, it's not in apparent conformance with the requirements of the Illinois Election Code. So it probably should have been rejected from the offset. But when it wasn't, it's deemed valid under the election code unless an objection is filed. I did file the objection within the stated time frame under the election code. And just by looking at the four corners of the nomination papers, both the petition as well as the statement of candidacy, it's clear that, at a minimum, Mr. Nowak is not running for the Republican Party, which is the ballot on which he's placed. Secondly, I think the board can probably, just from their own knowledge, I guess infer or know that there is no established party named the Republican Party. Now, I want to talk about briefly, I mentioned earlier, substantial compliance with the code. There's numerous case law, and I have brought some of the case law if any of you are interested in reviewing it, but essentially it says sometimes mandatory provisions aren't required or aren't fatal. General rule, probably fatal, sometimes not. It talks about, there's an instance in one case where there was roughly well in excess of 100 pages of petitions signed. And there's a requirement under the code that says you have to essentially organize those petitions by ballot, by sheet number and corresponding number. At one point, there's an individual who accidentally filed a petition sheet for another candidate. Therefore, page 176 was this other candidate, and therefore the logic of the objector in that case was, well, it's completely out of order now because, the sheet, really that page 176 should have been page 177, and then every sheet thereafter was out of order. The courts ruled that that was substantially compliant and didn't deem it fatal. There's other cases in which the uniformity of the petition document itself, if it's not of uniform size or what have you, it has all the required language, but under the election code, it has to be of uniform size. If it's not a uniform size, technically not in compliance. However, I think it would be likely that it would be considered substantially compliant if that were the issue. The issue we have here is we have a candidate who swore that he was running for the Republican Party, not once on any of the, throughout his nomination papers, the statement of economic interests, the statement of candidacy, the petitions, not once anywhere on it was it indicated that he was running for the Republican Party. He had numerous opportunities. I don't think by looking at his nomination papers as a whole, you would be able to infer without looking outside the four corners of the document, so to speak, or of those nomination papers, that he was running for anything other than the nomination paper. There's also, and so I guess as far as the statement of candidacy is concerned, that is roughly the argument I'm making. It's a mandatory provision. It states shall. It's not in compliance. The entire point of the mandatory provisions is for the Illinois legislature to ensure there's an orderly election, orderly filings, to make sure that there's no voter confusion. What we would have here is we would have a second party. Well, first off, he has stated and sworn that he's a qualified primary voter of the Republican Party. Therefore, he would be ineligible for the Republican Party. You can't infer anywhere within the nomination papers that he is a member of the Republican Party or intended to run for the Republican Party. We're past the deadline at this point for the nomination papers to be filed. So there's no way for an amendment to occur at this point without having the 3 statutorily required nomination papers of statement of candidacy, petitions, and statement of economic interest. He's failed to comply. At a minimum, he filed as a member of the Republican Party, which again is not an established party, and there would be no primary. So it would also presumably do the exact thing the legislature intended to avoid, cause voter confusion. When going around collecting signatures, one of the main goals is to make sure every signer of that petition is aware of the party that you're running for, which brings us to, I guess my argument on the petitions, in addition to stating that he's a member of the Republican Party, I believe 4 times per petition, including the section above the signature lines. It says, "We, the undersigned members and affiliated with the Republican Party and qualified primary electors of the Republican Party for District 3, and I'll skip around, but then shall be a candidate of the Republican Party for the nomination for the office of County Board Member, County Board District 3 in the County of 60102. To hold that someone who was referring to himself as a member of the Republican Party when collecting signatures in the County of 60102, it creates massive confusion as to both were these voters members of the Republican Party, a primary elector of the Republican Party when signing, but also it doesn't even refer to the county in which he's running for. And that's essentially the gist of my argument. Mr. Noack swore he's a member of the Republican Party. It's not in compliance with the Electoral Code under Section 710. And it's a mandatory provision. And at this point, there's no way for Mr. Noack to remedy the flaws, the mandatory flaws, which would, at this point, invalidate all of his nomination papers. And so for that reason, I'm arguing that he be removed from the Republican ballot, as he never indicated he wanted to run for the Republican ballot. And to infer with nothing anywhere within the filings indicating he wanted to run for the Republican Party would be an injustice, frankly. And I'm happy to take any, I don't know how we're doing this, but I'm happy to take any questions as well.
Do we let Mr. Noack respond before we ask?
Well, he could cross-examine Mr. Hendricks, he could do that if he wanted to, because he testified as a witness, so he could cross-examine if he wished to.
Do you wish to cross-examine Mr. Hendricks?
No, I have nothing to.
Then as far as, do we ask questions of Mr. Hendricks first, or do we allow Mr. Noack to respond procedurally?
I think you could do either. If you have questions for Ms. Hendricks, I think you could do it now if you wish.
I'm gonna sit tight. Do you have any questions for me?
I do not.
I do not either.
Okay. No. Mr. Noack, it's your opportunity to speak.
Okay, thank you. Good morning, everybody. My name is Robert Noack. I typed and I filed a petition to run for the county board, District 3. I want to say first that there was no intent to create, form, or start a new political party. I simply misspelled Republican. I forgot the C. It was my mistake. I truly admit it was my mistake. There was no malicious intent. There was no or deception in plan or deception planned in my action. I'm sorry for that. I truly made a mistake. I did not proofread the petition. I feel like I fell victim to auto check. I relied on the computer to make any and all corrections. As we all live in this electronic world and text and email, it seems like the corrections are made on misspelling. So I asked this electoral board if I could either correct the petition or have it accepted on its face value. I Googled the word I used, and all it ever comes up with is Republican. So I don't think there was any deception in the word, or, I simply forgot to see. It was something that I did. Basically, that's all I have to say. If you have any questions, I can answer them.
Just one, I guess, observation. So I understand auto check. I mean, I've done the same thing as well, but there are several instances where you hand wrote the word Republican.
Yeah. I don't know why. I can't explain that. I prepared the petition the Friday before the last weekend, receiving calls from constituents, people that I know. They wanted me to get into the race. I sat there Friday afternoon and I just typed it out on the computer, printed it out on the printer, and just moved on. I guess, like I said, I didn't proofread it. I should have. I generally have my wife proofread things because she's much better than I. I'm not the best speller in the world. I have to admit to that. But that's all I have to say. I just basically made a mistake. There was no, other than that,
And Mr. Hendricks, when you spoke, you said that there was, I don't want to misquote you, but generally speaking, you had said that there was a raft of case law that talks about when a mandatory clause is violated and it being fatal. Did you bring any of that you want to enter as evidence?
I don't know if it would be evidence. I'm happy to address it in my closing or better organize it for you.
Well, if you have a case or case law that you think supports this point, then I would say you should submit it to the board.
Yeah.
Okay, understood. If you just give me a moment.
Sure.
And then, before I do so, will I have an opportunity to briefly cross Mr.
Yes.
Nowak?
yes.
Mr. Nowak, do you agree that the election code requires you to put the party with which you're running for on your nomination papers?
I do.
And do you agree that nowhere on your nomination papers there was no reference of your intent to run for the Republican Party?
I don't believe that to be true.
Did you write Republican Party, either write or type Republican Party anywhere on your nomination papers?
I did.
Where?
In my mind, I did.
On the papers themselves, though?
Like I answered that question.
In your mind?
No, I did as I felt fit. I misspelled it, but I wrote it the way I thought it was.
And you agree that you wrote it incorrectly in that case?
No, I don't agree to that. I agree that I wrote it the way I believed it to be spelled.
Believe
And
what
that's
to
what I
be
did.
spelled?
Republican.
And do you agree that you did not spell Republican correctly
I do.
after having looked at
I
it.
said that.
No further questions. May I approach?
Oh, absolutely.
So here's the case, North First Hinkle out of the second district.
What was the name?
What's that?
What was the name?
North First Hinkle. Out of the second district.
Do you want to call this as an exhibit?
Yes.
And I don't know if everybody wants to read it in its entirety, or if you'd rather I just go through it and talk about it.
Why don't you give us your synopsis, and then we'll give it a read.
Sure, so just by going to the third paragraph under facts on page 1. There's an objection, if papers do not apparently conform to the code, defendant's under no obligation to certify that candidate's name for the ballot. This case was Hinkle when the city clerk for the city of Amboy did not certify the ballot. When you turn to page 2 under the analysis, there's 2 paragraphs on that page I'd like you to focus on. First would be under B, certification of candidates. It says the issue presented in this case is whether trial court properly concluded that under section 10.8 of the code, defendant possessed the authority to determine plaintiff's nominating papers apparently conform to the code's requirements. Skipping ahead to the top of the second column, the procedures for certifying a candidate's nominating papers are set forth in relevant part in section 10.8 and 15 of the code. Each election official with whom certificates of nomination or nominating petitions have been filed shall certify the names of all candidates entitled to be printed on the ballot. They go on to reference that this begs the question of which candidates' names are, quote, entitled to be printed on the ballot. And it says to answer this question, we must turn to section 10.8 of the code. Certification of nomination and nomination papers being filed as required by the code and being in apparent conformity with the provisions of this act shall be deemed valid unless objections thereto duly made. It's my position, as I've stated before, that they probably should have been, if filed, they should not be certified, or maybe they shouldn't have been accepted. But now that they have, they would be deemed valid until the objection I made. Once the objection is made, I think it's clear both from Mr. Noack's filings, nomination papers, as well as his testimony that he didn't conform with the provisions of the act. As it goes on, as we read the code, the candidate whose names are entitled to be printed on the ballot are those who nominate papers, and then they list 3 requirements. Filed as required by the code. Mr. Noack did file, but did not file as required by the code, referring to the errors that you previously spoken about. The second is in apparent conformity with the code when filed. It's not in conformity with the code. Again, section 710 of the election code requires that there are mandatory provisions, and one of those is listing the name of the party. and not subject to a duly filed objection. There is a duly filed objection here. And at this point, just looking at the four corners of his nomination papers, that in of itself shows it's not in apparent conformity. By Mr. Noack's own admission, it's not in apparent conformity. He admits that he didn't write it correctly. And then on page 3, on the second paragraph in column 2, section, as our conclusions suggest, we find plaintiff's position unconvincing. First, plaintiff's reading of section 10.8 is contradicted by the plain language of the section. Section 10.8 does not state that all nominating papers are deemed valid unless they're subject to a duly filed objection. Rather, the code states that all nominating papers being filed as required by this code and being in apparent conformity with the provisions of this act are deemed valid unless they are subject to a duly filed objection. And that's just, frankly, it's just not. It's not on the face of the document itself, you can tell it's not. I do have one more. I guess I would seek to, this is my third exhibit. This is Druck versus Illinois State Board of Elections.
Okay.
What's that?
Do you want to take us through your thoughts on?
Sure. Sure, I would just say generally, I think the content I'm looking at most begins on page 5 in the second column under challenged and unchallenged nomination petitions. It talks a little bit about the construction of the language that I referred to earlier in the last paragraph in the second column on page 5. This issue requires this court to examine the election code. Illinois courts are guided by established rules of statutory construction. The cardinal rule of statutory construction, and the one to which all other canons and rules must yield, is to ascertain and give effect to the true intent and meaning of the legislature. Our Supreme Court has consistently held that the most reliable indicator of legislative intent is found in the language of the statute. It talks about some of the provisions towards the bottom of the first column on page 6. Druck argued that his nominating this isn't a quote, this is me summarizing. Druck argued that his nominating papers were automatically considered valid unless objections were filed. The court goes on to state that after reviewing all the words and phrases in section 10.8 of the election code, we discovered that section 10.8 clearly codifies 2 conditions precedent that must be complied with in order for nomination papers to be valid. 1, the nomination papers have to be filed as required by the code, and 2, the nomination papers have to be in apparent conformity with the provisions of the election code. Before they're deemed valid, it's clear that nomination papers have to be filed with the right election authority and have to be in apparent conformity with the code's provisions. And then it goes on to talk about some of the signature requirements.
If I may interrupt for one moment, it's been brought to my attention that Mr. Nowak hasn't received a copy of the case that you.
Oh, I apologize. Yeah, I can provide a copy of both.
Thank you.
No problem. Give me 1 second. You can have a copy of, here's the first one, North First Hinkle. And here's the second one. And then in the second column of page 6, it goes on to talk about by requiring an election official to certify nomination papers for ballot access, the SBOE, which would be, I guess, the McHenry County Electoral, but a board equivalent in this case, but that was for the state board, can prevent the candidate from gaining access to the ballot. Section 10.8 makes it clear there's conditions precedent that must be complied with for nomination papers to be valid. And Section 10.14 makes it clear that election officials must certify a candidate's nomination papers as valid in order for the candidate's name to appear on the ballot. And in this case, the court actually did affirm the state electoral board's invalidation of the nomination papers. And you can find that on page 7 in the conclusion. And I would also just point out at this point that I don't think there's any dispute that this wasn't in apparent conformity. Mr. Nowak said in his mind he intended it to be a different party, but when gathering signatures, when swearing in under oath, when handwriting in, when typing in, not once can it be inferred from the papers what party he was running for other than the Republican Party. If you're looking anywhere in his nomination papers, not once was it mentioned where you could say, oh, maybe this was a typo. He swore to it 6 times. And if it's not in apparent conformity, that in and of itself would mean that these are invalid either because the election authority determined it or because at this point I'm bringing it to your attention through my objection. And I did look for a case that specifically talked about as far as the party name. I wasn't able to find any. But I think by inferring the logic between the statutory construction that our courts have used, which is to get to that must or shall means a mandatory provision. By not doing the mandatory provision in two parts. One, the party he was running for, mandatory would invalidate his nomination papers. 2, in the petitions themselves, it's announcing he's a candidate for 60102, not the candidate of the county of McHenry, it's the county of 60102.
Mr. Nowak, did you have anything that you'd like to say in response to?
Well, you know, obviously I'm not an attorney, and there's a lot of documents, a lot of case law, I'm sure. The only thing I can say, I've been a part of the Republican Party for many years, you know, over 40 probably, and in McHenry County. And you probably can look back at my record for years and years. I did truly misspell it. It was not my, I thought I was spelling Republican, not misspelling it. You know that's how the mind goes. Like I said, it was not intentional. It was just an honest mistake. In this crazy world, I can't imagine people going without making any mistakes. And this was simply a mistake I made. There was no intention to be part of any other party than Republican. It's been my life since I moved into McHenry County in 1978. So that's all I have to say.
I do have one last, but I do not have copies because I did not intend to use these as exhibits. But I do have Lawler versus Municipal Officer.
I'm sorry, what was the name?
Lawler versus Municipal Officer Electoral Board. It's a case out of the 1st District.
What's the site on that, please?
We could have some copies made if everyone's agreeable to wait a couple minutes. You agreeable, Mr. Hendricks?
I am.
Sure. Ms. Miano, would you hand it in?
Can I just see this balance out just in case?
Oh, sure.
label that one.
Thank
You have a copy of it?
I do.
So, Mr. Hendricks, take us through the substantive arguments from this case.
From
Lawler. Yeah.
Let me take a, did you have my original? That's where I made
I
notes.
did. I have an extra one.
There's some.
Otherwise, you can have this back.
Yeah.
Thank you.
Sorry about that.
So I apologize.
On your copy, you had notes?
I believe so, yeah.
Okay, that's the one that I gave to Joe.
All right.
Just put exhibit note on the top there.
So just, I guess the synopsis would be a good place to start. In order for the Circuit Court, Cook County affirmed a decision of the municipal officer electoral board declaring petitioner's statement of candidacy invalid because it was lacking in elements required by statute. There was an appeal. Held that under the statute requiring the nominating petition that it include a statement of candidacy which shall set forth certain matters. The nominating petition and statement of candidacy could not be read together so as to validate a statement of candidacy which did not itself set forth the matters required. Also held that the statute setting forth the requirements of the nominating petition and declaration of candidacy is mandatory rather than merely directory. And on page 3, it begins talking about 710, section 710 of the election code.
Mr. Nowak, anything to add to?
You know, like I stated, I'm not an attorney, and you know, this is a lot of my realm, more about construction and building, is my background. So, but when I look at these statements that Mr. Hendricks is submitting, none of them refer to a misspelling of a word. Am I mistaken by that statement or not?
So you don't get to ask us questions.
Oh, and that's where I'm a little confused. I'm sorry.
That's for us to determine whether it does.
Yeah. So that's all I really have to say. You know, in these particular cases, there seems to be other factors that caused a pulling of a individual off of a ballot other than a misspelling of a party's name. That's all I have to say.
And so I would say, oh, I apologize. So I would say Lawler in particular might be a good one to look at. There, the electoral board, the circuit court, as well as the appellate court all affirmed. It was from appeal to circuit court, or to the circuit court, because the statement of candidacy was invalid because it was totally lacking in the essential elements required by the provisions of 710 of the code. Essentially, some of the reasons it was held to be lacking is it failed to contain a statement by the candidate that he's a qualified primary voter of the Republican Party. That statement is lacking here. It does not state that he's a candidate for nomination of the Republican Party for the office. The statement of candidacy and primary petitions are all statements to be a candidate for a different office. So it's analogous in that way as well. And then it talks about that he failed to list the special election. That's not relevant here, but it also doesn't request that his name be printed on the official primary ballot for nomination of the Republican Party. And there, the electoral board, the circuit court, and the appellate court all affirmed that it wasn't in compliance. And on page 3, when it starts talking about the 710, section 710, that's when we get into whether it's mandatory or directory. It's mandatory. The appellate court affirmed the candidate being objected to in this case being kept off the ballot. And here, the petitioner contended, or the candidate contended, that the nominating petition, statement of candidacy, must be read together, that his petition and his certificate of candidacy substantially comply with the statute, and they disagreed. And then on the bottom of page 4, second column, requirements of 710 being mandatory, it was incumbent on petitioner to comply with its provisions. Because he failed to do so.
Yeah, we didn't get the even numbered pages,
Oh,
unfortunately.
oh no.
Yeah.
Let's, you know what?
One page.
Give me
The
this.
front side.
Yeah.
Here, if you didn't get it either, here we go.
I think we, the three
That
of us
would help.
I'm sorry, you were saying about page 4 or something or another?
Yeah, towards the bottom of page 4 in the second column, the requirements of section 710 being mandatory, it was incumbent on the petitioner to comply with its provisions. Because he failed to do so, the board correctly held initially that his name should not be placed on the primary ballot. And I guess I'd just also point out on the top of page 4, second column, the candidate in that case took the position that section 710 of the election code should be held in directory rather than mandatory, essentially to keep his name on the ballot. And then the objector in the electoral board contended in substance that the provisions in question are mandatory rather than directory. And the court notes, we believe the legislature, in spelling out the required contents of the nominating petition and the required contents of the certificate of candidacy separately, intended that compliance with both requirements be mandatory rather than directory. And then again, talks a little bit more about the language of shall and must being ordinarily interpreted as mandatory.
Mr. Nowak, any response to any of that?
No, I haven't.
Want to take a moment and deliberate? Sure. No, do you want to read some more? Okay. So now, as is those uninitiated, the deliberation takes place in the public forum, so you'll hear us talking amongst ourselves, as is part of the process. He argues,
You can, yeah, I'm sorry, go ahead.
yeah, so he argues apparent conformance, but as I understand and as we have applied from the State Board of Elections, it's the presence or absence of the required documents and a minimal amount of signatures that validates whether or not it's apparent conformance. I don't know that there is an argument in that particular vein. And feel free to, if you see that differently, the mandatory part is, so where I struggle is that it is mandatory, but at the same time it seems that Mr. Nowak was not trying to establish a new political party for his testimony. So it would be more of a script than a, what are your guys' feelings on that?
I agree with you. And when, I believe when you're filling in those fillable forms, if you misspell Republican or Republican once, I think it fills in the other particular spots for the party, at least when you're typing. I struggle with spelling it the same way by hand, but
Yeah.
I think it's a spelling error.
Yeah, I just think it's a misspelling. I don't think it has anything to do with auto population, but look at this case in the totality. There are two objections. Republican being misspelled as Republican, and then that zip code placed where it was county.
Right.
And, we've done a lot of these hearings. I've been doing it for almost 13 years now, but the law always favors ballot access.
Right.
That's what it favors. It starts with that premise, but you look at the objections in their totality and you give them credence. So I look at this and I think, okay, what motive would Mr. Nowak have to misspell that name? And I can't think of a motive. Was there an attempt to deceive? I don't know why you would do that. What would be the benefit of that? Or actual deception. And there isn't any evidence that anybody was deceived thinking they were nominating him for a different party than the Republican Party. And quite frankly, I think if you'd handed me this petition and said, hey, find what's wrong with it, I'm not sure I would have seen what was wrong with it.
Right.
I just don't think I would have.
And
No.
were you direct it to me or?
No, I wasn't directing it to anybody.
No, we're
No.
talking amongst the three of us at this point.
I don't think there was any confusion with the voters here as what party Mr. Nowak was being nominated for and to what office. I just don't think there was any confusion there or fraud on behalf of the voters. When we talked about the substantial compliance, and I would have to say I do think there's substantial compliance here. It's one misspelling, and I mean, some of the signatures are obviously Mr. Nowak's neighbors are on the same street. And there's no other party even close to Republican. It would be, if somebody had petitions that said, I nominate you for the Democrat Party as opposed to Democratic, quite frankly, I don't know which one is the proper party name. I think it's Democratic would be the proper party name. But would I believe that there was confusion as to what party you were being nominated for? No, I wouldn't. I wouldn't. When I look at that Lawler case, I don't think it really applies because, yes, it does talk about, substantial, it talks about compliance, but they even include this gentleman's statement of candidacy, which was a central point of this. And he made his own up as opposed to just following the form. And there's no party representation in it anywhere.
Right.
And if, I would just like to clarify, I'm not arguing Mr. Nowak defrauded anybody. What I'm arguing is that there's mandatory provisions. The mandatory provisions weren't complied with. As far as the apparent conformity, I do agree with Member Theriault in that his office would be acting in a ministerial role in that case. But once the objection is filed, at that point, it's the duty of the electoral board to find out whether it's in apparent compliance.
Yeah, which I think is what we're doing right
Yes.
now, yeah.
Okay,
Yeah, I
I just wanted to make it clear, I'm
Yeah.
not arguing
Right.
anything about fraud. I'm not arguing, anything about, whether Mr. Teeter, whether the clerk's office should have or should not have accepted it from the outset.
Because that was one of the cases, but the thing is just, I understand, I appreciate you're not arguing fraud or anything, you're just arguing that there should have been strict compliance, that Republican, because it was missing that C, that invalidates this petition. And I then look at those other factors, because that's what the case law tells me is, do I look at whether it confused voters, did it defraud voters intentionally or not? Was it likely to mislead a voter as to what they were signing? They still get to go vote, just get on that ballot, and that the access to the ballot is preferred, not that you have to give it, but it's preferred. And so I don't see those factors, quite frankly, that would lead me to believe that Mr. Novak should not be on the ballot because voters would have been confused, misled, or deceived as to the petitions they were signing. And it's the same, I think it's the same for that 60, the zip code being placed in, because if I look at that, yeah, I mean, at the top, his address is here, County of McHenry. County of McHenry is down everywhere, County of McHenry down below. Why you put in 60102, but I'm gonna assume that's a zip code in the County of McHenry, District 3. I don't think any of that would have misled a voter as to what they were signing, and that's kind of a threshold for me, is did it mislead somebody, did it confuse, did it deceive, was it likely to lead to fraud in an election, and I can't find it.
And Lawler does go on, in actually the very last sentence, I believe, of the decision. It just says, petitioner may, however, be a write-in candidate for nomination of that office. This isn't preventing Mr. Nowak from the ballot, but in order to be on the ballot, as a permanent ballot, he does have to be in compliance with the requirements. And it's
Well, this is, I understand, you've made those arguments, and this isn't our debate, Mr. Hendrick, sorry, it's not our debate, it's our time to deliberate. Mr. Nowak, you asked for whether you could file amended petitions, the answer is no, once they're filed, they're filed.
Right.
So I'll just tell you that right now, that's not even a possibility, but that's my, in all due respect, that's my position on it.
Right, agreed. And I think I go in terms of the preference to be on the ballot, and can't quote book and verse, but there's a predisposition to ballot access to such a degree that removing it is tantamount to invalidating your signatures on a, and it's a fairly serious matter to do that.
Any comments on this?
I think I have a case on point as the attorney representing the board, that Samuelson versus Cook County Officers and Board of Elections directly talks about that issue that the petitioner has brought up, and they found that when their errors are merely technical in nature, they should be reviewed under standard of substantial, not strict compliance. And then it goes down even further that when a deviation from the Illinois Election Code is minor or technical in nature and does not defeat the thrust, purpose, and effect of the statute or affect the legislative intent, and this is where they talk about the legislative intent right here, to guarantee a fair and honest election, it will not render that petition invalid. A candidate is deemed not to be in substantial compliance with the election code and completely ignores one of the statutory elements. Ballot access, this is to your point, ballot access is a substantial right and not likely to be denied. The Illinois Election Code is designed to balance the candidate's right to have his name appear on the ballot with the need to preserve the integrity of the petition process and to encourage qualified voters' participation. Before a candidate's name is removed from a ballot, both the rights of the candidates and the voters must be weighed, and the removal must have a rational relationship to a legitimate governmental objective. A minor error in a candidate's nominating petition should not result in candidates removed from the ballot. Moreover, substantial compliance with the election code is acceptable when the invalidating charge concerns a technical violation that does not affect the legislative intent to guarantee a fair and honest election. And the role of an electoral board is to decide whether or not the certificate of nomination or nominating papers or petitions on file are valid, or whether the objection should be sustained. And then again, they seem to repeat themselves on this one. They said on numerous cases, but they say our courts have previously held that substantial compliance with the election code is acceptable when the invalidating charge concerns a technical violation. Oh, here's the point. So even there, I think I covered that earlier, even when some of those provisions are mandatory, the fact that some of those requirements are mandatory as evidenced by the statute's use of the word shall is no bar to the application of this standard. And the standard being earlier, like I said, that substantial rather than strict compliance is the standard. So that comes out of the Samuelson versus Cook County Officers Board of Elections. So that goes to your point, if that was the case you were referring to about that on access.
And I do have a copy of that if you'd like it.
That's okay, we can, you have the site, I'm sure.
Yes, does anybody want to cite on that one?
And I would just like an opportunity to respond. I know this is deliberation, but a non-electoral board member did make pretty substantial arguments there, so I'd like to address them.
And then to that point, I'm just advising the board on the case that you were searching for, ballot access. And that case is cited as Samuelson versus Cook County Officers Electoral Board. And they're listed as 2012 IL App Lexus 315, as well as 360 Illinois December 658.
And in that case, I just want to point out that in my argument earlier, I referenced substantial compliance in terms of, I don't know if I said technical factor, but that was the case I was referring to when I said the consecutively numbered, there was a misincluded page 176, but that decision specifically talks about, here the record indicates that Samuelson never raised the issue of whether Brewer's papers were in apparent conformity. That's not what this is. They didn't consider that issue. The issue that they considered there was truly a technicality. He numbered them consecutively, but misincluded another petition, which obviously threw the entire thing off. That is a technical, as far as the substantial, as far as the mandatory language regarding the apparent conformity. It's apparent from the face of the document. Nowhere within the nominating papers are you able to conclude what party he's running to, running for Mr. Nowak, without going outside of that and trying to use your own judgment. The Samuelson court didn't contemplate this, and specifically said they didn't contemplate it because Samuelson never raised the issue of whether Brewer's papers were in apparent conformity, and they're not.
Anything to add, Mr. Nowak? I just want to make sure you have an opportunity.
Yeah, thank you.
That's all I had.
Don't have anything else.
Yeah. All right, so then the question is, do we sustain Mr. Hendrick's objection against Mr. Nowak's petitions? And voting among us, I say we do not sustain this objection.
I would overrule the objection. I would not sustain it.
And I also agree, I would not sustain the objection.
I think it's a very good argument, don't get me wrong, I think it's a very good argument, but I think there are a lot of factors that work against you on this, and that missing C is not enough to get over those factors.
Okay, so the decision of the board would be to overrule your objection in this case. A formal written response would be available.
Well, and also, just to be sure, procedurally, perhaps a vote would be in order.
That's what we just did.
Yeah.
Did you have a motion on all?
No, I don't think we just, we
All right.
voted it, it's 3-0 on that. And I think we have to reconvene, even though we will mail out the decision, it'll get mailed out, but we do have to reconvene in order to
Yes.
tender that hard copy. You can be here or not. If you're not, we mail it out. Okay. So what date would we do that?
Mr.
And I could have the decision ready pretty quickly.
So today's the 19th. So it's the 21st, that'd be Thursday, is that too soon for you?
No,
I don't know that I can be here Thursday.
When's the next chance?
I could come in Friday. I'm not working Friday, but I could come in on Friday. Thursday, I just have obligations all day.
Okay, how about you?
I'm not working Friday either, but I can be here. I may be casually dressed, but that's all
All right, all right. So Friday, the 22nd, should we say 9 o'clock, or is that too early? 9 o'clock, 10 o'clock? But I'll be here all day.
Depends on happy hour on Thursday night. I'll be here. You tell, you whatever time it's.
Let's say 10 o'clock.
10 a.m., okay.
All right.
So we're going to adjourn until that date,
Right, and then
until date 10, yes.
so we will reconvene Friday, the 22nd of December at 10 a.m. Presumably in the same room unless we give notice elsewise.
10 a.m. you said?
10 a.m. Any questions on any of that? Everybody get all that?
No,
All right.
thank you.
And as Deborah mentioned, you don't have to be here necessarily, but if not, we will certainly mail you a copy of the document. And with that, we